Hello, loyal blog readers. Welcome to this week's weekly wire in the class action world. I'm joined by my partner, Jen Riley, and today it's one of my most favorite topics, employment discrimination, class action litigation. Jen, give us an overview of the history of Title VII employment discrimination, class action litigation.
Thanks, Jerry. So historically, most cases brought in this area were brought under or have been brought under Title VII of the Civil Rights Act of 1964. Historically, courts granted class certification of claims brought under that statute at high rates, which sparked settlements of those cases at a high level. The landscape changed when the U.S. Supreme Court decided the case Walmart Stores versus Dukes. In that decision, the Supreme Court really raised the bar for class certification. In particular, the court addressed commonality. So with its decision in that case, commonality no longer depended upon the identification of a common question. In fact, from that decision now, we know that commonality depends on the plaintiff demonstrating that the claims depend upon a common contention that's capable of class-wide resolution or will drive a common answer that will resolve the validity of the claims in one stroke, such as an assertion of discriminatory bias on the part of the same decision maker. So that ruling made these mega classes, especially in the employment discrimination context, with different decision makers applying different standards, really a lot tougher to certify.
Thanks, Jen. I mean, with that background, it definitely makes sense that the Walmart decision is the 800-pound gorilla in every federal courthouse when class certification motions are being decided in all Rule 23 matters, but especially in the employment discrimination area. And my sense over the last 10, 11 years is that the plaintiff's bar is nothing if not innovative, and they have created a new approach and rebooted how to prosecute and seek certification in employment discrimination cases. And I think the watchwords are smaller classes and classes that are tied together with one particular discrete employment practice, like a hiring test, like a promotional test, like a pay increase. And so the days of classes involving 1 million or more people, Walmart itself was 1.5 million people, are gone. And so that the plaintiff's attorneys now are taking smaller shots, hitting singles and doubles rather than the grand slam that they might have gone for before. So as a result, in 2013, what we saw was a success rate or a conversion rate of lawsuits into certified class actions of about 53%. That was up from the year before, but again, we're kind of in a jump ball situation between the defense and the plaintiffs. And not all employment discrimination cases are equal, but those that involve discrete employment law policies and tend to be of smaller scale rather than larger scale tend to spike success for the plaintiff's bar. The other thing that I've noticed the plaintiffs are doing is certify something, and so more class certification motions brought for issue certification or on liability only and not damages, on the theory that if the plaintiffs can certify something, the defendants have a tiger by the tail, so to speak, and leverage shifts to the plaintiff's side, and that's a situation where more settlements, more often than not, will result. So Jen, what would be good takeaways for our listeners and readers in terms of that 40% block of cases where the defense was successful in opposing class certification in the employment discrimination area?
Thanks, Jerry. There are a few decisions that really come to the forefront of my mind when I think about successful challenges to Rule 23 motions in this context over the past year. A couple of those involve cases brought under Title VII for race discrimination. So the first is Brown versus Board of Trustees of the University of Illinois. In that case, the plaintiffs brought a class complaint asserting discrimination on the basis of their race in violation of Title VII. They essentially asserted that the university's non-discrimination policy was discriminatory, and also that the university's Office of Access and Equity engaged in a pattern or practice of discrimination by failing to promptly investigate allegations of race-based misconduct. Interestingly, the court evaluated the evidence that the plaintiffs put forward and found that the plaintiffs failed to demonstrate the commonality requirement of Rule 23A. Essentially, that even if the plaintiffs alleged correctly that the policy and the procedure were problematic, the court found that there was an evidence that anyone actually suffered a Title VII violation. So with that, the court then found that the plaintiffs had failed to meet their burden of showing that common questions were apt to drive resolution of the claims under Title VII. The second case that comes to mind is a case called Brown versus Houston Community College. In that case, the plaintiff alleged that the defendants subjected her and other Black employees to discrimination on the basis of their race in violation of Title VII again by enacting a policy to displace Black employees with white and Hispanic employees. The defendant just defended against those claims in that case with evidence that Black employees were actually the largest group of employees in the workforce, and by demonstrating that only minor changes had been made in the distribution of Black employees over a 5-year period. The court found that as a result of that, common questions did not predominate because individualized inquiries would be necessary to determine why each employee was subjected to an allegedly adverse employment decision. Jerry, can you tell us about some of the successful Rule 23 motions we've seen over the past year?
Well, I think there are two successful plaintiffs' motions in particular that provide plenty of takeaways in this particular area. Both involve New York City-based employers and plaintiffs. The first involved a case called Chalmers, involved the New York City Fire Department and a group of African American fire protection inspectors who claimed race discrimination with respect to pay as compared to white building inspectors. And based on anecdotal evidence, an expert statistical report, the court was convinced that the plaintiffs had successfully satisfied all of the Rule 23 requirements. Their case fit within the Duke's mold and granted class certification in a case where many thought that it would be impossible ever to certify either that large of a class or a class that involved different pay levels. The court was convinced that because pay was controlled by a civil service system and a collective bargaining agreement, that there was lockstep compensation, and therefore the court could adjudicate on a common basis the issue of whether or not someone was a victim of race discrimination. The other case was a private plaintiff case called Chen Oster versus Goldman Sachs, and it has a very long history. The case had been going on a long time, and the defendants argued very vigorously against certification of a class that involved female brokers and white-collar workers claiming disparate impact with respect to the way in which they were paid and with respect to their promotional opportunities. And the court eventually certified the case and determined that, again, at least on liability issues, that the plaintiff's theories could be adjudicated in one fell swoop. Now, one of the takeaways from that is before trial, within the last 2 weeks, the defendant in that case struck a settlement for $215 million. And at least thus far in calendar year 2023, the Chen Oster case is the largest employment discrimination class action. So it illustrates how conversion of a complaint into a certified class action creates leverage and oftentimes leads to settlements.
Jerry, can you address some of the settlements that we've seen in 2022, 2023 in this area?
In 2022, settlements for employment discrimination class actions more than doubled. It was a very robust year for the plaintiffs' bar. Among the top 10 settlements, 9 were gender discrimination class actions. 1 was actually a religious discrimination class action. But the total was close to $600 million. And I think that reflects the notions of social inflation and the fact that juries post-pandemic tend to award larger verdicts than before. We're seeing the advent of what are being called nuclear verdicts, even in single plaintiff cases. And so the plaintiffs' bar did a very good job in converting certified class actions into class actions that were settled and then approved by the court at a very high level, at a very high price.
Jerry, what do you see as on the horizon for corporate counsel in 2023?
I think 2023 is going to be another significant year. I mentioned before the $215 million settlement struck in the last few weeks in Metro New York area for a very large certified class action. There'll be more in the pipeline, but more importantly, I think you have plaintiffs' attorneys who have been successful in this space and who are willing to invest in these cases. To certify an employment discrimination case, you need an expert. That's an outlay of $250,000. So unlike the experience that defendants have had, for instance, in the wage and hour space, where there are multiple cases and many brought and not brought necessarily by skilled plaintiffs' lawyers, that's not the case in the employment discrimination area. They tend to be very serious cases, very well-researched cases, cases that are financed either by litigation funders or by plaintiffs' lawyers willing to make a large investment, especially when they have to pay for an expert that can cost $250,000. So I would expect the plaintiffs' attorneys to continue to operate on their playbook with smaller size classes, discrete employment policies at issue, and trying to certify something, knowing that in a fee-shifting situation with an employment discrimination statute, once a case is certified, it becomes a very, very costly and risky endeavor for a defendant.
Well, thank you everyone for joining us today. This concludes another edition of our Class Action Weekly Wire. I will note that we have just released our Consumer Fraud Class Action Review, which you can find on our website as well as our blog. Check it out. Thank you.